Tomorrow, the United States Supreme Court will hear arguments over whether or not former President Donald Trump is eligible to remain on Colorado's 2024 presidential ballot. As you know, back in December, Colorado's Supreme Court, in a closely divided decision 4-3, affirmed the lower court's decision to kick Trump off the state's 2024 ballot. The Colorado court relied on its interpretation of Section 3 of the 14th Amendment. That amendment reads, "Any member of Congress or officer of the United States who takes an oath to protect the Constitution and then engages in insurrection cannot hold office." In this case, the Colorado Supreme Court ruled that Trump engaged in insurrection on January 6, making him ineligible to run for office. So then what happened? Well, Trump is now asking the United States Supreme Court to reverse that Colorado ruling. The former president is now expected to attend the oral argument and instead will be at his Mar-a-Lago residence in Florida. According to CNN, Trump will start the day off in Florida and then head to Nevada for his expected caucus victory party. Harvard Law Professor Emeritus and Newsmax legal analyst Alan Dershowitz joins me. Good evening, Professor Dershowitz. Before we get to the constitutional issue, the court threw him off for insurrection. He has not been indicted for insurrection in Washington, D.C., despite what everybody thinks. But the special counsel has never indicted him for that and could have. Yet that's why Colorado bumped him from the ballot. So let's start there. What do you think?
Well, yeah, and that fits into Section 5 of the 14th Amendment, which gives Congress the power to basically define and implement Section 3. And Congress could have easily said, well, you need a conviction or you need an indictment, or they could have said, no, all you need is proof beyond a reasonable doubt. So there's Section 5. There's also the text of the Constitution itself. It doesn't mention the President of the United States. It goes out of its way to mention electors of the president or vice president, but not the president. And I think a textualist would say, look, you expect on that list would be a president, and there's no mention of the president. Then you can tell he's included among any other office holders in the United States. The general rules of how you interpret statutes require that when there's a lot of specificity and somebody's left out, that you generally interpret the statute to indicate that the framers intended to leave that person out. And that makes all the sense in the world, that when you have the highest office in the country, you don't disqualify a person from running who has millions and millions of voters who want to see him. So I think the court will find a textual, narrow way of saying that a president can't be, without congressional authorization, just taken off a ballot based on a Secretary of State or a state has the prohibited conduct.
All right, the decision was 4-3 in Colorado, and now it goes to the Supreme Court. We've got what some people say are 6 conservatives been appointed by Republicans and 3 Democrats on the bench. How important is it? I think it's extremely important this be a unanimous decision, because I think otherwise it really, if it's 6-3, that's just going to undermine any, people will never have any faith in these courts.
I agree with you, and I think that the Chief Justice's hardest job is to try to wrangle cats together and create a 9-0 decision. I also think a decision saying he's not disqualified is more likely to be unanimous than a decision that would disqualify somebody. I cannot imagine all the conservative justices agreeing to a decision disqualifying the man who is the leading candidate on the other side. But I could imagine at least the 3 liberal justices saying, look, democracy should prevail. As I've said over and over again, I have the right to vote against Donald Trump for the 3rd time, but don't deprive me of that right by using some constitutional technicality. So I'm not making a prediction because I don't know what's in the minds of the Supreme Court, but I think the most likely outcome is that the Supreme Court will find a textual or procedural way of overruling Colorado without getting to the issue of whether he actually engaged